Good
Hello and
afternoon.
welcome. Go ahead, Mary Meg. I'm sorry. Go ahead.
No, that's okay. Good afternoon, everyone. We are so grateful that you're with us today. My name is Mary Meg McCarthy, and I'm the Executive Director of the National Immigrant Justice Center. Today, we have an exciting program, an exciting and timely program, and we're glad that you are with us. What has changed with immigration under President Biden? We have an outstanding team of NIJC leaders who are going to share with you what we are seeing on the ground, both in terms of our services to clients as well as in our advocacy and our policy work. President Biden made promises on the campaign trail to address the harmful policies of immigration and to build an immigration system that respects human rights and diversity for our nation. Since the beginning of the year, we have seen some developments, and that's been really exciting and positive. And as we move forward in talking with members of the administration and the White House, we have really been hopeful about what is possible and where we're going. But we must recognize that the system was severely damaged and that political tensions remain, and we have a pandemic that ensues. Given those challenges, we have continued to advocate strongly for human rights and for a system that recognizes the dignity of each and every individual. But we know that communities across the country are struggling with the uncertainty that exists, with the difficult times that we are facing in so many ways. Sealing the border and continuing to embrace racist and unlawful summary expulsion of families, of individuals that place them in danger. We recognize too that we have backlog courts and pro bono capacities is stretched paper thin. But we must continue to move forward despite these challenges and fight for a fair day in court for each and every individual. We are moving forward, and today we are excited to talk to you about what we are doing at the National Immigrant Justice Center with a team of extremely resilient, hardworking, and committed individuals, as well as with a pro bono network that has made a difference in the lives of thousands of individuals. To our partners, thank you for joining us and working with us in advancing a fair and humane immigration system. And to the community that have joined us today, thank you. You're playing a critical role in staying informed and sharing the information and knowledge that you have with other members of our community. With that, I am so honored to pass this on to the extraordinary NIJC team who you'll hear from today, beginning with Ellen Miller, our pro bono manager. Thank you.
Thanks, Mary Meg. As Mary Meg mentioned, my name is Ellen Miller. I'm the pro bono manager, and I'm excited to kick us off today. In preparing for this presentation, we realized there are so many topics to discuss, and many of you are joining for very different reasons. So for the hour, we have intentionally decided to provide highlights of the work that is happening, some of which Mary Meg just also reviewed. We do have additional resources on our website, and our presenters will be providing links in the chat as we go, and we'll also send a follow-up email with some of those links, so no fret. The presentation is being recorded, and a link to the recording will be shared in that follow-up email. All of you right now are muted, but we love to see your questions and your comments as we go. So there's a chat function right kind of down on your screen, depending on the device you have. And we welcome you to actively engage with us throughout the presentation. Our team will be responding in the back, and then we'll definitely leave time for questions and answers at the end. So you will soon hear more about NIJC's integral service model that combines direct legal services, policy and advocacy with federal impact litigation. Today, as Mary Meg said, we have an exceptional panel of competent and very compassionate colleagues. And they're going to demonstrate how these three pillars come together. So Lisa Koop will start us off by talking about asylum, what's happening on the border and across the country. Trisha Teofilo Olave will walk us through the exciting developments with U visas and the immigrant survivors of crime. Next, we'll transition to a topic that makes front page news, DACA. Vanessa Esparza-Lopez and Nayna Gupta will provide updates on all angles, legislative, executive, and judicial, that continue to ping pong the politics for DACA recipients and their family. Keren Zwick will wrap us up by providing highlights from various courts that impact federal laws and policies. And we will talk about what you can do to help this mission, and of course, leave 10 to 15 minutes for Q&A. Just briefly, if you are not familiar with the National Immigrant Justice Center, we are an immigrant legal service provider, and we work to ensure human rights protections and access to justice for all non-citizens. We have offices in Chicago, San Diego, Indiana, two in Indiana, and Washington, D.C. With our pro bono network of more than 2,000 volunteers, we've provided legal services to more than 9,000 individuals in this past year. These individuals and families come from more than 105 countries around the world. And of course, you and our community keep us ticking. So before we transition to Lisa, who I know is ready and eager to tell us all about asylum, I just want you to try out this chat function for us. Let's see if it works, eh? And drop in the chat right now. What changes are you happy to see under Biden? Okay, what changes are you happy to have seen that are happening right now, or that are hopeful, that you're hopeful for? Or you can also include, what concerns and questions do you have? So what are some things you might be hearing about, seeing on the news? What's some things that you'd like to hear more about today? Drop those in the chat. We'll take a look at those right now, see what's coming in, okay? I see some things here. So Daniel's asking about the DACA progression and what's going on. Raising the refugee admission cap. Okay, Caitlin, let's see what we can do. We see a lot here about DACA. Asylum procedures, reunification of families. Thank you, Evelyn, that is right. Oh, I see BFD for U visa. Jacqueline is dropping in some good lingo here that Trisha's gonna hit on. So we're excited. Let's see here. DACA changes. Why are they still keeping kids in cages? Thanks, Violetta. We'll see what we can do. We have some information on that on our website, along with Title 42. Richard, I see your question. So let's get started then. I'm going to turn this over to Lisa Koop to kick us off and talk about asylum.
Hi, everyone. I'm obviously very eager to come and talk to you about asylum, so apologies for my early appearance there on the video. But I work with NIJC's asylum team. I'm based in Indiana, and I also work with a lot of our projects along the border. So primarily, NIJC has been doing work down in Laredo, Texas, and following a lot of asylum cases that have started there and come to the Midwest, where our clients, as many of you know, the bulk of our work happens before the Chicago Immigration Court. So we're looking at these asylum issues from a lot of different perspectives. I think it is fair to say, as we are about 7 months into this administration, both that the Biden-Harris administration inherited a chaotic border situation where systems that may have allowed for humane treatment of immigrants were intentionally dismantled, and that this administration has not been bold enough, they have not been fast enough in their efforts to restore and rebuild a system that prioritizes human rights. So the picture you're seeing now on your screen kind of tells this story a little bit. So you're seeing the side-by-side of the Laredo tent courts, or tent facilities, which were erected in September of 2019 at the beginning of the Migrant Protection Protocols, or the Remain in Mexico program, when it was implemented in Laredo. And what you can see there on the left is the kind of the shipping containers you can see where we were holding asylum trials for clients that were forced to remain in danger in Mexico during their asylum proceedings. And then on the right, you can see earlier this spring, the shipping containers are gone, but those tents are still there. And it's kind of curious that they still are, and maybe a little disconcerting that this hasn't fully been dismantled yet. And earlier this year, as the Migrant Protection Protocols were beginning their phase 1 of a wind down, we propose that those facilities be repurposed and become reception centers and maybe be used to provide Know Your Rights presentations and to orient asylum seekers and other migrants who are coming into the United States as they were going on. Most are not staying on the border. Most are going on to other places like Chicago, like Indiana, or the East Coast or California or wherever. And we thought it would be really powerful if those spaces could be used now to orient people to the system. And we never heard back from the White House. They didn't take us up on our offer. And that's sort of emblematic of what we're seeing. A lot of the good ideas that I think advocates have to help push things in the right direction, help restore human rights protections, aren't getting off the ground yet. And so that's a frustration among a lot of advocates. So we can go on to the next slide and talk a little bit about the fact that people that were subject to remain in Mexico and to Title 42 are still facing harm. This phase one wind down of the migrant protection protocols or remain in Mexico is happening very slowly, despite the fact that nonprofit organizations that run shelters on the border and legal services organizations that are operating on the border have really made a lot of proposals about ways that they could more efficiently and more compassionately provide assistance to people transitioning in, receiving parole into the United States in order to exercise their right to seek asylum. And that is, a real concern. We were seeing when we were down there, a lot of slow walking happening by individual Customs and Border Protection chiefs, so people that were in charge of certain sectors, indicating that they could only take a certain number of asylum seekers paroled in per day, despite the fact that capacity was greater than that. And so there was a disconnect that we observed between the messaging coming from the highest levels of government and what was actually happening on the ground. And that translates to a lot of people still stuck in these systems where they're being harmed and where they're not able to safely seek asylum and secure protection for their families. So Title 42 remains in place. Title 42 is that public health law that the prior administration used erroneously to justify sealing the border. And there was a lot of anticipation that when the new administration came into power, that Title 42, or T42 as we call it, would be promptly rescinded, but it's still in place, and that's really problematic. One, because it was never a legitimate use of that law in the first place, and two, because people who are entering the United States to this day are still being summarily returned to Mexico without any type of screening for whether they have asylum claims, without any type of due process or access to counsel. And we are, for example, seeing clients arrive or asylum seekers arrive in the Midwest who were subject to Title 42. We met a woman a couple of weeks ago who was turned around with her young daughter at the border and handed over to Mexican authorities, who then handed her off to a Mexican cartel that held her hostage for a month. And she was mistreated horribly and abused in really horrific ways during that month until her family managed to pay for her freedom. And she was able to then represent herself at the United States border, and this time she was allowed to come into the United States. But that can't be our system of justice. That's not how asylum is supposed to work. And for every day that Title 42 remains in place, stories like this continue to accumulate. So we can go to the next slide and maybe just talk briefly about kind of what we're seeing in the asylum context now. And some of these things have persisted over multiple administrations, and there's still a lot of room for improvement. So of course, there's no appointed counsel, which is, the clarion call to pro bono attorneys who are at firms that have the resources to handle asylum matters. The need still outpaces resources, and we're always looking for partners to work with us to handle these asylum cases in order to ensure that these families are able to access protection. We're now seeing clients presenting layers of trauma. So people that were, fled their home country, made that excruciating decision to make the trip to the United States only to find that they were stuck in Mexico for a year or 2 years where they were subjected to additional harm. And so they're coming to us having experienced just layers of trauma that make it even more difficult for them to prepare their asylum cases. And so that is most definitely a residual effect of the prior administration and the ongoing harm perpetrated by this administration that we will see for years to come. Court backlogs means that we can't get our clients in front of an immigration judge to have their cases heard. Clients are still have limited access to employment authorization, and a lot of them have a lot of anxiety about these alternatives to detention. So a lot of them are required to report weekly or monthly through an app on their phone, and they're forever concerned that they're going to somehow bungle these requirements and wind up in ICE detention or wind up being placed on an ankle monitor. And so in most of these cases, any kind of ICE monitoring or check-in is really not necessary. As we know, when someone has an attorney, the likelihood that they will stay involved in their case and show up for court is extremely high. So we really want to see a wind down of these alternatives to detention and the use of these apps on people's phones. In the chat, I think it was Ben Weinberg mentioned the Attorney General decisions that were rescinded. So this is where we can kind of shift a little bit from, these spaces where we really still see a need for improvement into some of the more positive news. So the Attorney General's vacature of matter of AB, matter of LEA, matter of ACAA, if that's just alphabet soup to you, that's okay. What those decisions were decisions issued under the prior administration that tried to say that if you're fleeing gender violence, if you're fleeing violence because you were harmed by gangs in your country, then you're not eligible for asylum in the United States. And that's never been what our asylum laws say, but those decisions really prejudiced those sorts of claims under the prior administration, and they've now been rescinded, which is really good. And that ACAA decision meant that when you went to the Board of Immigration Appeals, you kind of had to fight your whole case all over again. Even if you won before an immigration judge, the Court of Appeals could find a way to deny your claim. And so we're kind of tiptoeing our way back towards some semblance of due process. And that is a very good thing. And you'll see here pictures of some of our clients that recently won protection. So a young man in June who was granted asylum, who went to court with our colleague Wes Brockway from our Indianapolis office. And then those are 9 unaccompanied minors who in the course of a week were all granted protection in the Chicago Immigration Court. And that's really terrific because it shows that when immigration judges are given the power and authority to control their dockets, when the attorneys that work for ICE, the Department of Homeland Security attorneys, are able to exercise prosecutorial discretion, we can resolve some of these matters in a way that is fair and that is just, and we can get some of these families towards stability and safety. So with that, I will pass the presentation to my colleague Trisha, who will talk to you about DACA.
Thank you, Lisa. I love that alphabet soup, and I'm going to throw more at our audience here, and also cheers to due process. These are some great progress that we're finally seeing under the Biden administration. So my name is Trisha Teofilo Olave. I am a fully accredited representative with the Department of Justice and a senior legal supervisor here at the National Immigrant Justice Center. I supervise our U-Visa Pro Bono project, and so today I'm going to be talking to you about the U-Visa and the new bona fide determination process that affects thousands of people who have pending U-Visas. So what is the U-Visa? Well, the U-Visa was created back in 2000 as part of the Victims of Trafficking and Violence Prevention Act. And it's a non-immigrant visa that was created to strengthen the ability of law enforcement to investigate and prosecute crimes, okay? Now, it's important to understand that immigrant victims of crimes are often reluctant to assist in the investigation or prosecution of criminal activity for fear of being deported, right? And so this visa was created as sort of a win-win scenario. We'll help you if you help us. So the idea being, if immigrant victims can assist in the investigation and prosecution of these crimes, then law enforcement will assist by signing the U-Visa certification that is required for someone to apply for a U-Visa. Okay. It also, of course, helps fulfill the humanitarian goals of Homeland Security. So we can go on to the next slide. The U-Visa is a great tool. It's a great form of relief that many people qualify for, unfortunately, right? There's a lot of victims of crime here in the United States. The biggest downside to the U-Visa is that there's an annual cap of only 10,000 U-Visas per year. This needs to be fixed. We're hoping that someday that cap will be raised or eliminated. But for now, there are only 10,000 U-Visas that can be granted each year. And so because of that limitation, there is now a huge wait list, okay? There's a huge backlog of U-Visas, and over the years, USCIS created this wait list to allow people who are otherwise eligible for the U-Visa, but there is not currently a visa available for them, allow them to be placed on this wait list while they are waiting for their U visa. So that sounds great. However, during the Trump administration, the wait list became so backlogged that it is now taking over 5 years to get placed on the wait list. So we have many applicants who are eligible for U visas. They have filed valid U visa applications, but they're waiting. They're waiting with such instability and uncertainty because most of our clients anyway, don't have work authorization while they're waiting for their U visas to be adjudicated. And so it creates a lot of uncertainty in their lives. Fortunately, the Biden administration and USCIS recently initiated this new bona fide determination process, which just took place in June. And so we're just starting to see the positive effects of this process. If you can move on to the next slide. Basically, USCIS is now going to review all pending U visa applications, and they're going to review them in a first come, first served order. So by order of receipt, I should say. So the applications that were received first will be reviewed first, and they're going to be reviewed to see if they meet the qualifications for a bona fide determination. Is the application complete? Has it been properly filed? And are there any criminal, national security, or public safety concerns? Okay, so those are basically the 3 things that USCIS is going to look for in making this determination. So what constitutes a complete application? Well, first of all, did the applicant fill out Form I-918? That's the U visa petition. And was it signed properly? Okay, unfortunately, if the application wasn't signed properly, it's not complete. Does the applicant's application include a signed U visa certification? So that's that certification that I mentioned from law enforcement that is absolutely required with a U visa application, okay? And that certification had to be signed within 6 months of filing the U visa application. So what I mean by that is if my client obtains a U visa certification signed by law enforcement today, August 10th, then that application needs to be filed before February 10th of next year. Otherwise, it's no longer valid, okay? And then finally, does the U visa application include a signed statement by the applicant, which details how they are eligible for the U visa, okay? So if those 3 pieces of the application are there, then the application can be considered complete. Was it properly filed? So it needs to be actually received and properly filed at USCIS. And then USCIS will issue a biometrics appointment for the applicant to go have their fingerprints taken, and they will run a criminal background check to make sure that there are no national security, public safety, or other concerns that would make somebody ineligible. If a U visa applicant passes this bona fide determination, then they will be granted what's called deferred action, which is a sort of protection from deportation. And with that deferred action, they can get a work permit. So a work permit is a huge benefit for most of our clients, especially for victims of crime who, like I mentioned, often don't have a way to work legally here in the United States. Having valid employment authorization can provide them with the stability to support their families. So if a client is granted this bona fide determination, they will get deferred action and a work permit until, and it's renewable until their U visa is granted, and that is their path towards citizenship. If someone does not pass this bona fide determination process, then they go into the old process, waiting to see if their case is placed on the U visa wait list. Okay, so it's not that their case would be automatically denied, rather it's that they would go into the queue for being reviewed, just like the cases were before this bona fide determination existed. Okay, so somebody that files their application today, their application hopefully will be reviewed for a bona fide determination. If they don't pass that, then they will likely be waiting a few more years, and hopefully at that point be placed on the U visa wait list. At that point, USCIS will determine if they need any additional information, possibly issue a request for evidence or something like that. But if everything is fine, then people can be granted U visas. Next slide. So just to give you an idea of what this looks like for our clients, Nellie, we've changed her name. This was a client for a case that we worked on back in 2016. Nellie came to us as a victim of domestic violence, which is one of the qualifying crimes that makes someone eligible for a U visa. There are certain crimes that make someone eligible, and Nellie qualified. She came to NIJC and we filed her U visa petition back in August of 2016. She has been patiently waiting, but over the course of the years has been very anxious due to the instability, anti-immigrant sentiment that she's felt in her community. She was fearful of ICE raids. She called us very concerned over the years. And at the time, we didn't have much news for her except that she had to keep waiting. Well, fortunately, Nellie's case was recently granted a bona fide determination, and she now has work authorization. And being able to provide her with that means to support her family is life-changing for Nellie. So it's really important that these processes exist. I'm excited that many more of our clients are going to have this opportunity. And I want to thank all of you for your support, especially those of you that are working on pro bono cases with us. I'm going to go ahead and turn it over to my colleague, Vanessa Esparza-Lopez, who's going to talk to us about DACA.
Thanks so much, Trisha. And so, as Trisha mentioned, my name is Vanessa Esparza-Lopez, and one of the roles that I play at NIJC is to oversee our DACA pro bono project. And so, before we get to what's the current state with DACA, I just want to take us back a little bit and explain how the program started and how we got to where we are. So, the program was started under the Obama administration in 2012. And it was a combination of Congress's inability to pass legislation like the DREAM Act, combined with a forceful organizing effort by undocumented youth that led Obama to create the DACA program in the first place. And we're now coming up on the 9th anniversary on August 15th of when the government agency started accepting applications for this benefit type. At the height of the program, over 800,000 individuals benefited from DACA protections, which includes deferred action, similar to what Trisha just mentioned. It's a similar type of deferred action as offered under the U visa benefit, which means the individual is protected against deportation for a certain period of time. In this case, it's a 2-year period. And for that same 2-year period, the individual gets lawful employment authorization. And so while the DACA program has certainly been great at providing opportunities and stability for our clients, ultimately it is not the permanent protection our families and our communities deserve to feel secure in this country. And this is clearly evidenced by the ongoing litigation that has impacted the program since the Trump administration announced the rescission of the program in 2017. So shortly after the rescission announcement was made in September of 2017, there were several lawsuits filed across the United States. And the majority of the 10 lawsuits that are referenced on the slide, actually all of those 10 lawsuits that are referenced on the slide, were filed by plaintiffs that supported the DACA program. And essentially the lawsuits were arguing that the creation and the implementation of the DACA program was within the Obama administration's power to do so within his authority as the executive. As well, they also argued that the Trump administration's attempt to end the DACA program violated the law. And so several of these lawsuits were consolidated and made their way through the district courts, the circuit courts, and ultimately were consolidated and heard before the U.S. Supreme Court. And now the U.S. Supreme Court issued a decision last June of 2020. Now, in its decision with regards to the DACA program, the Supreme Court did not decide on whether the DACA program itself is constitutional, whether it's a legal program. However, what the Supreme Court did find was that the steps that the Trump administration took to end the DACA program violated the law. In particular, it violated a section of the law called the Administrative Procedures Act. And so we, as advocates, were obviously, excited for this decision, and we celebrated the decision. And after that decision, we felt that the DACA program was fully restored to its existence under the Obama administration. Next slide. Unfortunately, the agency under the last administration took a different position. After the Supreme Court decision, USCIS, or U.S. Citizenship and Immigration Services, the sub-agency under the Department of Homeland Security that adjudicates these cases, they doubled down and issued some memos over the summer of last year that instead of restoring the DACA program, further restricted it. And in summary, those memos indicated that the agency was not going to accept and process requests for initial DACA applications. As well, it indicated that it was going to restrict a DACA recipient's eligibility to apply for and receive advanced parole. And now advanced parole is an ancillary benefit available to some DACA beneficiaries, which allows them to travel outside of the United States and return lawfully. But the scheme post these memos for obtaining advanced parole was much more restrictive than what existed under the Obama administration. And finally, those memos limited the grant period for DACA beneficiaries from 2 years to 1 year. And this had a significant impact for our clients. All of our clients are at or below 200% of the federal poverty guidelines. So as it is, for a lot of our clients, it's difficult to save up the $495 filing fee required to timely renew their DACA benefits every 2 years. After these memos, they were going to have to come up with that money every single year. Next slide. Okay, so then the litigation continued. So even after the Supreme Court decision, after these memos were issued by USCIS over the summer of 2020, the lawsuits continued. And two significant decisions that we received in the recent past were first and foremost, a decision out of the U.S. District Court in New York in the Batalla Vidal versus Wolf case. It was issued last December. And in that case, the district court judge vacated those summer 2020 USCIS memos and ordered the government agency to fully restore the DACA program, which meant included accepting and processing first-time DACA applications. And the reason that the judge vacated those memos was because he found that the then acting Secretary of Homeland Security, Chad Wolf, issued those memos when he did not have the authority to do so. The judge found that, there's a certain succession that needs to be followed under the law as to who serves as the acting secretary when the person prior to them steps down or is removed. And the Trump administration did not follow that succession that is laid out in the law. Then, so that's why the judge felt that he could vacate those memos, and which led to the full restoration of the DACA program. So mid-December, our office started filing these initial DACA applications once again. And we had continued to submit those applications up until, early July, as well as many legal service providers across the country. Unfortunately, then we had another decision on July 16th in the Texas v. Nielsen case. This is a case stemming out of district court in Texas. And in this case, the plaintiffs, so this lawsuit, I mentioned earlier that the majority of the lawsuits were filed by individuals supporting the DACA program. However, in this Texas v. Nielsen case, this was filed by the state of Texas and 8 other states. And the states were arguing that the DACA program itself was illegal. So we had a decision in July from Judge Hainan in that case, who agreed with the states that the DACA program is illegal. And so from that judgment, the judge indicated that while USCIS can continue to accept initial DACA applications, they cannot process those applications. So they can accept them, they can cash the money order, but that's where it stops. So unless some sort of intervening action remedies Judge Haenen's decision, for now, initial DACAs that are filed, or all initial DACAs that were pending before the government have been placed on indefinite freeze. And if somebody files now, again, they'll cash your money order, but it's going to be placed on a freeze. He took a little bit of a different position with regards to people seeking DACA renewals, and in part doing so because, you know, individuals have been applying for and renewing their benefits for almost 9 years now. We've had clients at NIJC who are coming back to us for their 4th or 5th time applying for this benefit. So he said that they had a different reliance interest. And so basically the judge said that while this litigation is playing out in the courts, DACA renewals can continue to be accepted and processed by the government. And so what we're left now is with a lot of confusion, right? Because we have these two decisions from district courts. So these are courts that are at the same level within the federal government, and they are in tension with each other. And to be clear, we feel that Judge Haenen got the law wrong in the Texas versus Nielsen case. The US law gives the executive a vast authority to refrain from detaining and deporting community members and providing affirmative relief programs in the exercise of individualized discretion like the DACA program. And where we're left now is that the Department of Justice has indicated that they are going to appeal the Texas decision. And the Biden administration has stated that it is going to pursue rulemaking to ensure that the DACA program can remain in place. The problem is that in the meantime, while these processes play out, they take time, and thousands of people are once again in limbo, and they're uncertain as to whether they have a permanent place in this country and whether they'll be able to support their families. Next slide. And so who are the DACA recipients? And so while we look at these statistics, I just want to bring it back and say that most of us know somebody that has DACA or that who is undocumented because they are a part of our communities, they are our family members, they are our coworkers. So it's important not to lose sight of that as we talk through these political debates and these, you know, this litigation that's playing out in the courts. But as we look at these statistics, we see that since this, at the end of June 2021, there was over 81,000 applications for initial DACA benefits pending with the government. So that means that all of those initial DACA applications have been put on indefinite freeze because of this decision. And you see there as well other figures with regards to top 5 countries for active DACA recipients and top 5 states for active DACA recipients, Illinois being the third most state there. In terms of what we do at NIJC, you know, since the DACA program started, we've held over 160 pro bono clinics with our law firm partners, not only in the Chicago area, but across the United States. We have a nearly 100% approval rate for our cases. I mentioned we have clients that are coming back to us for the 4th or 5th time to renew. And we've had nearly or over 100 community Know Your Rights presentations so we can educate the public on what's going on with the DACA program. And so it's clear to us now that Congress needs to do something here, and I'm going to toss it over to my colleague Nayna to talk about the legislative prospects.
Thanks so much, Vanessa. Hi, everybody. So as you just heard from Vanessa, you know, DACA recipients in this country have been on a roller coaster. They've been subjected to the whims of changing administrations and protracted litigation. And so, as she said, the best way to protect DACA recipients is to offer them a pathway to citizenship, to offer them a way to have full legal status here in this country. And so right now, as you may be reading in the news, there's a lot of talk about legalization generally, but especially for those with DACA in Congress. And so some key pieces on this, you know, on the day President Biden took office, he promised to send a bill to Congress that would create a pathway to legal status for undocumented individuals. Unfortunately, that bill, the U.S. Citizenship Act, which is one of the 3 listed on this slide, hasn't really made much progress. The other 2 pieces of legislation that address legalization, including the Dream and Promise Act, which would help folks with DACA and TPS achieve legal status. Both of those passed in the House, but have no hope of passing in the Senate. And so thankfully, there does remain one possible way for the president and this administration to deliver on the promise of legalization, and that's through what's called the reconciliation process. And I'm happy to share links after this that explain more on reconciliation, but in broad strokes, unlike the normal legislative process, bills that go through reconciliation are not subject to the Senate filibuster. That means that a budget reconciliation bill, these bills are related to taxes and spending in the budget, could pass with a bare majority of 50 votes, with the vice president serving as the tiebreaker. So as a result, Democrats could create a path to citizenship without any Republican support, so long as all 50 senators in the caucus support a budget reconciliation bill. And so this is actually the best option we have right now for getting legalization for some of our communities who don't have status. The ability to do this, though, is not a guarantee. The bill would still have to pass through a provision known as the Byrd Rule, which I'm happy to share more details on in the chat. But in terms of the populations that we believe will be covered through this reconciliation vehicle for legalization, the proposal on the table right now would offer farm essential workers, farm workers, and DACA and TPS recipients a pathway to legalization. So it wouldn't be a pathway for all undocumented individuals in this country, but it would offer a pathway for many folks, including especially those that Vanessa was talking about, who have received DACA in the past. Again, we don't know if this reconciliation process will work, but it's the only remaining shot for this session of Congress and likely the next session of Congress for pushing through some version of legalization. And we're in the process of reconciliation on a budget bill right now. Something that is important to the work that we do at NIJC is also being defensive on bad provisions that relate to legalization that often are introduced by members of Congress in conversations on how to provide this pathway. And so one piece that we are always pushing back on is the idea of not having trade-offs in this push for legalization. So while we may legalize some members of our immigrant communities, we don't want to do that at the expense of others. In the past, under prior administrations, we've seen positive steps forward for some and harsher and punitive enforcement for others. And so at NIJC, we are always pushing back on those kinds of trade-offs, since our clients are folks with different various statuses, different backgrounds, but all part of the same families and same communities. We also push back on any provisions in a package like the reconciliation package related to increased money for border enforcement, and because of the harms we know that has on our communities. And then most importantly, one of the most challenging pieces of this work on legalization is ensuring that individuals who have had contact with the criminal legal system, who've served their time and their debt to society, are not excluded from this pathway to legalization. The INA already includes criminal bars, and some of these pieces of legislation layer additional bars on top of what is already in the INA, which means that many immigrant individuals, especially Black and Brown immigrants who have disproportionate contact with the US criminal legal system, are more likely to be cut off from the legalization process. I'm happy to answer more questions about the details of reconciliation and what we're doing in Congress. But as Vanessa said, right now, what we're hoping is to provide relief to those with DACA from this insane roller coaster that they've been on by winning legalization for them through reconciliation. So I think with that, I'm passing it off to Keren on our litigation team. Thanks, Keren.
Hi, everyone. I'm Keren. I'm the Director of Litigation at NIJC. We're a little bit short on time, so I'm just going to jump right in and focus on what I think is a big question that we have had. As folks may or may not know, the Trump administration issued a lot of rules. So rules are like the sub, they're not part of the congressional traditional lawmaking. They're passed through the agencies, and they're the way that the executive branch is able to make effectively a lot of law without actually passing a law through Congress in the traditional sense. And the Trump administration issued dozens and dozens of regulations that all got challenged, including numerous regulations that were issued at the very end of the Trump administration in November and December of 2020. NIJC in the past years has challenged 6 of those regulations. The ones, I'm not going to go through them all on the slides, but we filed 6 cases. Many other organizations that we have worked with have filed other cases, and we've partnered with other organizations on these cases. The ones at NIJC that we have focused on are rules that have attempted to restrict access to asylum, whether at the border or in the interior, through things like sending asylum seekers from Honduras and El Salvador to Guatemala with instructions that they must seek asylum there. Limiting access to work authorization for asylum seekers is another one that we have challenged. And then the other 2 cases that we have focused on are with respect to the due process protections that exist for immigrants before the immigration courts and before the Board of Immigration Appeals. Issues like access to continuances and access to a valid briefing schedule. The thing that's important to know about all of these challenges is that every single one of them remains pending, even today, 8 months after the inauguration. And they will remain pending for quite a long time. Next slide, please. And the reason for that is because in order to undo a regulation, you can't just have an election and have the new president erase the old regulation. What would have to happen is that the agency has to review the regulation. So this box, as you'll see on the screen, the box on the screen is a small quote from one of our status reports to the court in one of our cases, where the government states that the rule is being reviewed by the agency. But that means that in order for the cases to go away, for the old rules to go away, and for our litigation to go away, new regulations would have to come into existence. And out on the screen, you can see like a little faint lines behind in the back, which you're not meant to read. That's just the list of all of the things that got put on the regulatory review, and that's just the ones for DHS and USCIS, for EOIR and USCIS. So there are hundreds and hundreds and hundreds of regulations that are on this regulatory agenda that the agencies all state that they're coming to, and that would have to be addressed before any of these litigation issues can be fully resolved. So we're in for a long haul, and we're going to be spending a lot of the next year continuing to hopefully work to undo the harmful regulations that happened in the past year. Next slide, please. Next slide. But that's not to say that there aren't some good rays of hope, because, for example, one of the regulations that we challenge has to do with something called asylum cooperative agreements, which are those issues that I was referring to of Salvadoran and Honduran nationals being sent to Guatemala to seek asylum. On the plus side from that, the Biden administration has allowed all of our individual plaintiffs in that case to return to the United States as part of their agreement that they no longer intend to rely on that asylum cooperative agreement with the Guatemalan government. On the downside, though, we have heard a lot of rumors that the Biden administration is contemplating an asylum cooperative agreement with Mexico, which would be extremely disastrous because it could mean that the US government would allow any asylum seeker who is not from Mexico, could force any asylum seeker who is not from Mexico to go seek asylum in Mexico. So it would be even worse than potentially something like the Remain in Mexico program where you have to wait there. Instead, you would just have to be there permanently. This is still in rumor mill phase, and so we're just waiting to see, but we haven't dismissed our litigation about the asylum cooperative agreements whole cloth because we believe that that litigation would also be a vehicle to challenge expansion of the program into Mexico. Next slide. So setting aside the rules, there are other areas in which there are some, there's some goods and there's some bads coming from this administration. On the issue of family separation, so family separation is obviously what happened when the Trump administration announced a zero tolerance policy at the border, suggesting that every person would be prosecuted for illegal entry into the United States, which resulted in the caging of kids. Folks know that there was a lawsuit challenging that program, and then also NIJC has been working on a damages action challenging that same program. And both of those cases are making, we think, positive progress towards settlement. So settlement would include potentially financial compensation for the families that were separated, and also a formal end to the program and some kind of declaration that it couldn't happen again. So that's positive, but it's not yet over. Those negotiations are still ongoing. On things like interior enforcement and like the race-based interior enforcement case that NIJC filed, this was a case that involved basically the Immigration Customs Enforcement driving around predominantly Latino neighborhoods in Chicago and arresting people for essentially driving while brown. We have reached a settlement in principle in that case, and I think that we are hopeful that that case will be fully settled in the next several months. The settlement in that case will pose some requirements for ICE, both nationally and especially locally in the Chicago area, and then also throughout the Midwest for cities that are under the Chicago area of responsibility. So those are really positive developments that certainly would not have happened under a second Trump administration. The two bottom arrows on this slide that have arrows going in both directions reflect areas of NIJC's litigation docket that are going to continue and probably are going to grow. Habeas, somebody mentioned in the chat that they were excited to see so many people getting released from custody. That's been largely, before in the Trump era, we had to file a lot of habeas petitions to make that happen. Since then, we've had a lot more success with administrative release requests and other advocacy and bond hearings and hearings before immigration judges. But the number of people who are in detention continues to grow and grow and grow to the point where we are approaching Obama era numbers already. And so we anticipate that we will continue to see a lot of habeas and detention related litigation in the years to come. And then finally in the courts of appeals, where the reality is that President Trump put a lot of very conservative members on the Board of Immigration Appeals, and the Board of Immigration Appeals is now quite a conservative body that issues a lot of really bad decisions. And I think that we will see a significant increase in the number of appeals, particularly from protection-based cases, going to the circuit courts for judicial review. Next slide, please. So what does that mean for NIJC's work in the next coming year? We try to do a lot of different things at NIJC, as this presentation overall indicates, and that our litigation team is no exception to that. So this is just sort of how we see our time being split between these various buckets of work. We will continue to do systemic litigation on issues that would change the whole system, but we also are trying to be very mindful to set aside time for things like petitions for review and prolonged detention challenges and those kinds of issues, and also, of course, for the not insignificant amount of ongoing cleanup we have to do from the Trump administration. And I think with that, I can pass it back to Ellen for questions.
Great. So that was a highlight of a number of updates that are happening now across the country. And I just want to make sure that we are grounded before we sign off for the hour. And Eleanor Roosevelt generally helps us stay grounded. And she's asked the question, you know, where do human rights begin? And she answers the question soon after, saying in small places, close to home, so close and so small that they cannot be seen on the maps of the world. And so here's a list of opportunities where you can get involved, being a pro bono attorney that listens to their client, reading an article and visiting the website to stay informed, calling your representative to voice your concern or support. This is how we stay close to home and we make a big difference by our small actions. To continue to join us in our efforts and the mission, there are some events that are coming up. We know that a lot of our clients have walked very, very far across countries, and so we also invite you to walk or run for justice. On August 28th, we will be having a celebration run or walk in Indiana. We invite you to join us, and there is a virtual event also if you cannot join us in Indiana. We do have two events coming up, one in both in September, one for SIJS, which is exciting updates for child protections here in the state of Illinois. And then we'll also be talking about a recently released report talking about offshoring the right to asylum, what countries are doing, US, Great Britain, Australia, how they are impacting this offshoring. So now we have just a couple of minutes and we want to respect the hour here because we know that time is valuable. And so we understand that there's still lots of questions, and I know our team has been just typing away in the back. If you could also give us your feedback, you know, right now or in the coming minutes, hold up your device to the screen here, and you can enter a 5-question survey to give us your feedback on what you thought of today, and more importantly, what you'd like to hear more of as we craft these presentations moving forward, so we can do more in depth of specific topics. I'm going to just quickly toss this over because there's a lot of questions in the chat about T42 and what the pandemic is doing and what does protection mean. So I'm going to give the last words here to Lisa Koop to kind of summarize where we are looking at moving forward with protections and how we can continue to act. So Lisa, you've seen the questions in the chat about everything going on. Do you have some last words here about moving protections forward, especially with the Biden administration?
Yeah, thanks everybody. Thank you for your incredible engagement today and your just really thoughtful questions. You know, I think we had really hoped at this point, even as early as in July, we had heard that Title 42 was expected to be at least rolled back in part by August, and we're not there yet. And so our government needs to hear from us that we don't tolerate this, we don't accept this treatment of asylum seekers and other immigrants who are coming to reunify with their families or to leave conditions that just aren't tolerable anymore. And so we remain very hopeful that wrong will be rolled back. And in the meantime, we do continue to see asylum seekers. We talked a little bit in the chat about the fact that there are people who are continuing to come in. Right now, we have 47 cases on our pro bono case list that are waiting for a good home with a loving attorney who's ready to pick it up and help bring someone from instability to safety through legal protection. So we're really hopeful that those of you who are connected to law firms will think about joining us. And if you're not a lawyer, but you know one, you know, nudge them our direction. And if you're not a lawyer, that doesn't mean you don't have a role to play in the movement. And we welcome your support in so many ways. We're so glad you were here today. We're so glad that you'll be having these conversations with your communities and pushing people to move us towards justice and continue the work. Thank you all so very much.
Thank you, and we'll see you soon. Bye-bye.